Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
All these petitions followed a common pattern, and the main grounds of attack were that the state legislature was not competent to pass the said act, the topic of legislation not being covered by any entry in the state list, that the said act was beyond the aim bit of Article 31A of the Constitution and was therefore vulnerable as infringing the fundamental rights enshrined in Articles 14, 19, and 31 thereof, that the provisions of the said Act in fact infringed the fundamental rights of the petitioners conferred upon them by Articles 14, 119, and 31 of the Constitution, and the said Act was a piece of colorable legislation, and in any event, a part of the provisions thereof suffered from the vice of excessive delegation of legislative power. Stop. The definition thereof in Article 31A of the Constitution, and that therefore it was not open to challenge under Articles 14, 19, and 31 thereof, and that it was neither a piece of colorable legislation nor did any part thereof come within the mischief of excessive delegation. Stop. As to the legislative competence of the state legislature to pass the impugned act, the question lies within a very narrow compass. Stop. As already stated, the impugned act was a further measure of agrarian reform enacted with a view to further amend the 1948 Act, and the object of the enactment was to bring about such distribution of the ownership and control of agricultural lands as best to subserve the common good. Stop. This object was sought to be achieved by fixing ceiling areas of lands which could be held by a person, and by prescribing what was an economic holding. Stop. It sought to equitably distribute the lands between the landholders and the tenants, and except in those cases where the landholder wanted the land for cultivating the same personally, for which due provision was made in the act, transferred by way of compulsory purchase all the other lands to tenants in possession of the same, with effect from April 1, 1957, which was called the Tiller's Day. Stop. Provision was also made for disposal of balance of lands after purchase by tenants, and the basic idea underlying the provisions of the impugned act was to prevent the concentration of agricultural lands in the hands of landholders to the common detriment. Stop. The tiller or the cultivator was brought into direct contact with the state, eliminating thereby the landholders who were in the position of intermediaries. Stop. The enactment thus affected the relation between landlord and tenant, provided for the transfer and alienation of agricultural lands, aimed at land improvement, and was broadly stated a legislation in regard to the rights in or overhand. Stop. categories specifically referred to in entry 18 in list 11 of the 7th schedule to the constitution, which specifies the head of legislation as land, that is to say rights in or over land tenures, including the relation of landlord and tenant and the collection of rents, transfer and alienation of agricultural land improvement and agricultural loans. Stop.